At the end of your interview on the 4th of June, you volunteered to police that they would find a small quantity of cocaine in the principal bedroom of your house, stating that you and Dawn used to use it, quotes, just for a bit of fun, ... I just wanted you to know it was there, close quotes. You made no mention of having taken cocaine on the 31st of May or at any later time. Having regard to all such matters, I am sure that you had taken cocaine on the 2nd of June to strengthen your resolve to carry out your murderous plan. After Miss Spencer had left to go home, and in line with your earlier discussion with X, whilst Dawn was in the kitchen, X suggested that she close her eyes and hold out her hands to receive a surprise. Having pre-selected a drawing to give to Dawn, X went to retrieve it from the living room. Whilst Dawn was in that vulnerable position, you slit her throat in a rapid and forceful action which caused an incised wound 13 centimetres long, severing her carotid artery, jugular vein, trachea, esophagus and thyroid gland, also causing muscle damage and missing her spine by just a couple of millimetres. She was rendered unable to speak or scream. The incision caused an arterial spray which covered the floor and much of the walls in her blood. Having regard to the expert pathology evidence and the jury's rejection of your evidence that it was Dawn who had been the aggressor, I am sure that you inflicted that fatal wound from behind. Attacking her from the front would have made it more likely that she would have been able to avoid your attack, and defies logic where self-defence or defence of X has been rejected by the jury. Furthermore, and irrespective of X's mistaken recollection of the presence of a breakfast bar in the kitchen on the 2nd of June, on your own evidence, you had left the murder weapon in the sink or on the draining board at an earlier stage, and thus it was readily to hand in the kitchen area to which Dawn had had her back. Having instructed X to go upstairs and wait until you called X to come down again, you inflicted 2 wounds to your own head, the jury having rejected your account of an attack by Dawn, and subsequently a wound to X's left forearm, visible to this day and serving as a constant reminder to X of your heinous acts, with a view to supporting your account of self-defence. It was in that way that X had become aware and been able to indicate to the call handler who had answered the 999 call that Dawn was then lying on the floor of the kitchen. Having murdered X's mother in the most brutal way, you came to appreciate, at the latest by the time of your abortive first criminal trial, which had ended in December 2016, after X's video-recorded police interview had been played in court, that significant aspects of X's account had been at variance with your own. During supervised contact visits thereafter, as you acknowledged in evidence, you had opportunities to speak to X about what had happened and other matters which you were forbidden to discuss. I am satisfied that you reinforced the importance of X, quotes, sticking to the plan, close quotes, telling X that you would otherwise go to prison and that X would never see you again, and thereby encouraging X to perpetuate a false account. In X's words, quotes, I was made to feel like if that were to happen, it would be all my fault, and I'd lose my mum and my dad over the same event, close quotes. I find it unsurprising that X craved your affection and attention during these visits, given X's age, the trauma which X had experienced, and the fact that X's mother had first left the family home following the breakdown of your marriage and then died. I turn to the sentences to be imposed for your crimes. I have given very careful consideration to the evidence received at trial, to the helpful and detailed written notes on sentence and oral submissions received from the prosecution and the defence, and to all of the case law to which I have been referred. I am obliged to sentence you in accordance with all applicable statutory principles, sentencing guidelines and case law, and to explain my approach. I am very conscious of how detached and tortuous that exercise might appear to all those affected by your actions and to the general public. It in no way minimises or loses sight of the human impact of your offending, at which no right-minded person could feel anything but revulsion. I take your offence of murder as the lead offence, the sentence for which will reflect the overall criminality of your offending. The sentence for murder is fixed by law. It is a mandatory life sentence. Section 321 of the Sentencing Act 2020, to which I shall refer as the 2020 Act, requires me to decide the minimum term which you must spend in custody before you can be considered by the parole board for release on licence, unless I am required by Section 321, subsection 3, to make a whole life order, whereby you would never be released. Such an order is mandatory, where the court is of the opinion that because of the seriousness of the offence of murder, or of the combination of that offence and one or more offences associated with it, it should not make a minimum term order. On your behalf, Ms. Graham acknowledges that counts 2 to 5 are offences associated with your offence of murder, within the meaning of Section 400 of the 2020 Act. By its nature, murder is an extremely serious crime. The period which a murderer must serve in prison does not reflect the value of the life taken, nor does it attempt to do so. Grave though your wife's murder and associated offences were, your offending did not include any of the non-exhaustive factors set out at paragraph 2.2 of Schedule 21 to the 2020 Act, and I do not consider it to be one of those rare cases, the facts of which nevertheless merit a whole life order. I am satisfied that a very lengthy, finite minimum term will afford just punishment. I must therefore consider the appropriate starting point for determination of the minimum term which will apply. It is important that you and the public understand that a minimum term is just that. It is the shortest period which you will spend in custody before you can be considered for release. There is no guarantee that you will in fact be released at the end of that period or at any later time. It is only if and when the parole board decides that you are fit to be released that you will be released, and you will then remain subject to licence for the rest of your life. If you reoffend or fail to comply in any other way with the conditions of your licence, you may be recalled to continue your life sentence. It is in that way that a life sentence protects the public for the future. As Ms. Graham concedes, in all the circumstances, your offence of murder, in combination with your associated offending, might properly attract a starting point of 30 years. I am in no doubt that the seriousness of your offence of murder, in combination with your associated offending, was particularly high. I reject the Crown's submission that I should treat your offence as a murder done for gain. Whilst in the event you benefited from your wife's estate and life insurance policies following her death, I have found that your motivation for her murder was sexual jealousy, and the prosecution case was advanced on that basis. Nevertheless, the following factors lead me to the conclusion which I have reached. First, your significant premeditation and planning, including consideration of various means by which you might kill your wife, and your decision that involving X would bolster your intended claim to have acted in lawful defence of yourself and X, an approach also serving to blacken your wife's name and thus to increase the distress caused to her family. Second, your grotesque involvement of X, then under 10 years old, by manipulating and or nurturing X's conflicted feelings towards your wife, before soliciting X's participation in the plan to kill her, and thereafter suborning X to conceal the true circumstances of her death, encouraging X to lie to the police over a protracted period, reminding X of the need to, quotes, stick to the plan, close quotes, and indicating that a failure to do so would mean that you would go to prison and that X would never see you again. Third, your infliction of physical injury to X and using the knife with which you had recently killed X's mother, which has left enduring physical and mental scarring. Fourth, as apparent from the content of the 999 call made on the evening of Dawn's death, causing another person to believe that Dawn had attacked you and X and to witness the aftermath of your actions. Fifth, that Dawn's murder was committed in a domestic context in the family home on an occasion on which she had been present in order to visit X. Sixth, your use of cocaine in advance of Dawn's murder in order to boost your confidence to commit it. Seventh, and using your words, the, quotes, great distress and anxiety, close quotes, which Dawn Rhodes had experienced by reason of your actions in the period prior to her death, when she had come to fear that her telephone was being hacked and that she was being followed and at risk. I reject your account that, notwithstanding the multiple online searches which you had conducted, you did not in fact access her personal or work telephones, whether by hacking or otherwise. Eighth, over the same period, your emotional manipulation of Dawn Rhodes, including by goading her and by threatening suicide and self-harm, threats which were of sufficient concern to her that she contacted the police in January 2016. Ninth, the inquiry which you made of your colleague as to whether he knew of someone who could injure Dawn's new partner in exchange for payment, and your exploitation and manipulation of his wife's emotional vulnerability, of which you had been aware, including by the adoption of a false persona. 10th, the circumstances surrounding the 2 counts of perjury of which you have been convicted, arising from your prolonged and persistent giving of false evidence, first in earlier criminal proceedings to avoid conviction, remediable only via a retrial by order of the Court of Appeal Criminal Division, and then in family proceedings. That criminal conduct delayed justice by more than 8 years and risked a different outcome in the family proceedings, with all that would have entailed, including the prospect that X would have felt unable to give a true account of events. In those circumstances, the appropriate starting point in determining the minimum term is 30 years. I must then consider any relevant aggravating and mitigating factors. When considering the former, I bear firmly in mind the need not to double count any factor which has inclined me to consider that the seriousness of Dawn's murder, in combination with one or more of your associated offences, is particularly high, so as to have resulted in the selection of the appropriate starting point. I am satisfied that the significant degree of planning and premeditation to which I have referred is reflected in that starting point, and that there is no separate statutory or other aggravating factor which applies. The only mitigating factor in this case is the absence of any prior conviction for violence, or, in all the circumstances, other relevant conviction. You will receive some credit for that, though inevitably, given the nature and gravity of your offending, it can be of very limited significance. Ms. Graham advances as additional mitigation the provocation which she asserts to have been constituted in your wife's admitted infidelity, correctly observing that, as a matter of law, provocation of that type is capable of providing relevant mitigation for murder, even if not amounting to a defence. I am satisfied that there is nothing in this case which could properly amount to provocation by Dawn Rhodes serving to mitigate your offence. She had become increasingly unhappy in your marriage, considering that you were controlling. It was a marriage from which she wished to extricate herself, a decision which was for her to make. Furthermore, in late October and early December 2015, prior to your awareness of Dawn's extramarital relationship, you had yourself conducted 3 searches via a dating app. I reject your explanation at trial that you were simply being nosy following the mention of that app by your colleagues. More generally, I am satisfied that Dawn's new relationship was in large measure a reaction to your own conduct. You will receive no downward adjustment for provocation. Having regard to all of the above, I consider that the appropriate minimum term in your case is one of 29 years and 6 months, from which the time which you have already spent on remand will be deducted, as I shall explain later in these remarks. Your offence of cruelty to a child was constituted in your willful assault by infliction of a wound to the left forearm of your own child. That offence was committed prior to the 28th of June 2022, such that the maximum sentence which applies is 10 years imprisonment, whereas for an offence committed on or after that date, the maximum custodial sentence is one of 14 years. Having regard to the applicable sentencing guideline, I assess your offence to have been of very high culpability, category A, by reason of a combination of your use of very significant force, your use of a weapon, and your deliberate disregard for the welfare of X. The harm caused I assess to be category 2, being physical and related psychological and emotional harm falling between categories 1 and 3, as detailed by X in X's victim personal statement. For an offence so categorised, committed on or after the 28th of June 2022, the starting point is one of 6 years custody, with a category range of 4 to 8 years custody. Aggravating your offence was the fact that it was planned and committed with a view to concealing your wife's murder, your deliberate concealment of the offence itself, including by procuring X's continued false account of the way in which it had come to be inflicted, its commission under the influence of cocaine, the fact that another person was caused to witness the aftermath, and the blame which you wrongly placed upon Dawn Rhodes. Your lack of previous convictions for violence affords your only mitigation, and once again, in all the circumstances, can be of very limited effect. In light of the sentence to be imposed on count 1, the question of dangerousness does not arise for consideration. Had your offence been committed on or after the 28th of June 2022, the custodial sentence which I would have imposed would have been one of 7 years and 9 months. Having regard to the lower maximum sentence applicable to your offence, in my judgment, the appropriate sentence is one of 6 years and 9 months. I shall explain my approach to totality at the end of these sentencing remarks. I turn to consider count 3. 6 acts were particularised as tending and intended to pervert the course of justice. In each case, you disputed that you had acted as charged, subject to which you did not dispute any other element of the offence. As Ms. Graham acknowledges, in light of that, and of your conviction on count 2, the jury must have been satisfied that the 3rd and 4th particularised acts, the infliction of a wound to X's left forearm and causing X falsely to tell the police that that wound had been caused by Dawn Rhodes, had been proven. Similarly, your conviction on counts 4 and 5 indicates that the jury must have been satisfied of the 2nd particularised act, inflicting a wound or wounds to your own head and left hand, because it must have been satisfied that there had been no prior knife attack by Dawn Rhodes. By parity of reasoning, it must also have been satisfied that of the fifth and sixth particularised acts, causing X falsely to tell the police that wounds respectively to your head and back had been caused by Dawn Rhodes. I cannot be sure that you in fact caused X to inflict a wound or wounds to your upper back, the first particularised act, acknowledging that the superficial nature of those wounds does not correspond with the force with which, on X's evidence, you caused X to inflict them. However, given the nature and number of the acts of which the jury must have been satisfied, I consider that any such additional act would not materially have added to the gravity of the offence charged by count 3 for sentencing purposes. Having regard to the relevant sentencing guideline, I assess your culpability as high, category A, encompassing as it did conduct over a sustained period which was planned and related to an underlying offence of the utmost gravity. I am satisfied that the harm caused was category 1, given the serious consequences for X and the wider Rhodes and Spencer families, the serious impact on the administration of justice, and the substantial delay caused to the course of justice. For a category A1 offence, the starting point is 4 years custody, with a range of 2 to 7 years custody. In my judgment, the number and nature of your acts and the presence of multiple factors within the category requires an upward adjustment of the starting point before consideration of aggravating and mitigating factors, taking it to the top of the category range. There are no aggravating factors which have not been taken into account when selecting that starting point. Very limited mitigation is afforded by the absence of relevant recent convictions. Thus, and subject to totality, the appropriate sentence on count 3 is one of 6 years and 9 months imprisonment. Count 4 concerns your offence of perjury at your criminal trial in May 2017. There is no applicable sentencing guideline. I have had regard to the case law to which I have been referred. By Section 1.1 of the Perjury Act 1911, the maximum sentence is 7 years imprisonment. As I have already observed, your offence resulted in your acquittal and the denial of justice for a period exceeding 8 years. It was a deliberate, planned offence which drew in the young child whom you shared with the deceased. Its purpose was to avoid conviction for the most serious of offences, and it is deserving of punishment commensurate with the gravity of that offence. Once again, your lack of recent relevant convictions counts for very little by way of mitigation of this serious offence. Subject to totality, the appropriate sentence is one of 4 years imprisonment. Count 5 concerns your separate offence of perjury in proceedings in the Family Division in May 2018. Once again, that offence was deliberate, planned, and drew in X. It had the capacity to affect the ultimate outcome of those proceedings, though did not in the event do so, and marked a persistence in the lies which you had told in the criminal proceedings a year earlier. Some very limited mitigation is afforded by your lack of recent relevant convictions. Subject to totality, the custodial sentence which I impose is one of 3 years. But for the sentence imposed for the lead offence of murder, I would have imposed concurrent sentences on counts 2 and 3, with the sentence for count 4 running consecutively to those imposed on counts 1 to 3, and the sentence for count 5 consecutive to that imposed on count 4. Having regard to totality, I consider that the appropriate approach, reflective of all of your offending and resulting in a just and proportionate total sentence, is to impose the sentence which I have identified for each of counts 2 to 5, concurrently with the sentence to be imposed on count 1. I shall now summarise the sentence which you will receive and what it means for you. For the murder of Dawn Rhodes, I pass the only sentence which the law allows me to pass, being life imprisonment. You will remain in custody until the parole board decides that you are suitable to be considered for release. The shortest period of time during which you must remain in custody is 29 years and 6 months, less the number of days which you have spent remanded in custody, including in relation to the related offences charged by counts 2 and 3. I have been told that, as at today's date, that period is agreed as being 590 days. Therefore, the minimum term which I impose in your case is 27 years and 321 days. I remind you that there is no guarantee that you will in fact be released at the end of that period or at any later time, and that if and when you are released, you will remain subject to licence for the rest of your life and may be recalled to continue your life sentence if you reoffend or fail to comply in any other way with the conditions of your licence. For your offence of cruelty to a child, I impose a sentence of 6 years and 9 months imprisonment to run concurrently with the sentence imposed on count 1 and with all other sentences. For your offence of perverting the course of justice, I impose a custodial sentence of 6 years and 9 months to run concurrently with the sentence imposed on count 1 and with all other sentences. For your offence of perjury in 2017, I impose a custodial sentence of 4 years to run concurrently with the sentence imposed on count 1 and with all other sentences. For your offence of perjury in 2018, I impose a custodial sentence of 3 years to run concurrently with the sentence imposed on count 1 and with all other sentences. In light of the sentence imposed on count 1, you will not benefit from the early release provisions which would otherwise apply to the sentence imposed on each of counts 2 to 5. Therefore, the total sentence which I impose is one of life imprisonment with a minimum term of 27 years and 321 days, taking account of the time which you have spent on remand. The prosecution contends that you have benefited substantially from your criminal conduct, from your wife's estate and the proceeds of certain life insurance policies. An order prohibiting disposal of assets was made by Guildford Crown Court on the 28th of February 2025. In due course, the prosecution will seek a confiscation order relating to such wealth as remains and represents realisable assets. In that connection, I have made agreed orders and directions under the Proceeds of Crime Act 2002. For that reason, no order is made at this stage for compensation or for payment and collection of a victim surcharge. An order for forfeiture and destruction of the knife was made at an earlier stage. That is all.
something quickly from me. I can just give you.
Yeah, can we do a slightly different face to where the problem will be? Well, no, just so it's maybe just turn it a little bit. But don't. We are all standing by.
Waiting for, whether the family are going to say anything. I don't know if anyone will.
It's only going to be the police. Shall I lift that up?
I can.
And the reporter in the background, is he...
No, he's out.
Right. Oh, no, is he?
Okay, we're rolling.
It's really quiet, isn't it, Mike?
Sorry?
She's very quiet.
Just speak up as much as you can.
Well, it's an extraordinary unusual case, and but what you see during the first trial is extremely rare acquittal of a man in self-defence in which he has to portray the victim as demonstrative of what he did in that first case, and he relied on being able to support that case. There was a total failure, it seems to me, by the first team to explore the underlying evidence and to explore evidence that was available at the time that trial. The second trial, is not being done all along. Obviously, there was the principle that the trial had changed their evidence around it, but because of their own it tells us so much about what is and about tells us how we can really need to understand the underlying dynamics of the
of setup without you moving. A looser shot. Shall we move away further?
Just do 2 shots on the ground.
Yeah, that's fine. Then we can just a quick setup.
Bit of level for Eugene. How's that for you, Eugene? Bit of level for you.
Yes, it is.
Sorry, mate. It's
No, no, no,
out
that's-
of order,
no,
and
it's not-
it is
no,
out
it's
of
not.
order.
I'm sure we can. That's what this road thing is for.
It's
Okay.
great. Yeah. It's actually a road mic, so you'd think it would fit, wouldn't you?
Well, it's just a bit of Velcro. We'll do tight. Whoops. Okay, just keep holding it tight.
Yeah.
Keep holding it tight. How's that?
That's great. That's great.
to hide the manacles. Yes, I'll have the call. Let's see now. Photos are done now, yeah. How was it? think
We've done it this way round.
nice.
We're going to stand. Yes, you do. Oh, it's just stand before the
Yeah. Do you want to come stand with me, Libby, and then you're going to go first, yeah?
Up close to the mic, please. It's noisy here.
Okay.
Can you introduce yourself, please, Cameron?
Okay, I'm Libby Clark. I'm a specialist prosecutor with the CPS in the South East. Robert Rhodes thought that he'd got away with murder after he killed his wife Dawn in 2017. Thanks to the bravery of the child witness in coming forward in this case, he has now been convicted of the murder of Dawn Rhodes. Dawn's voice has now been heard. The new evidence in this case showed just how much careful planning Rhodes had put into murdering Dawn, making it appear to the original jury as if he had acted in self-defence, when in fact nothing could have been further from the truth. He persisted with this throughout the trial. Double jeopardy cases are exceptionally rare, and applications to quash acquittals are only made in the most serious of cases. It is never easy to prosecute these cases, and everyone involved at the Surrey Police and the Crown Prosecution Service, both in the South East and in our Appeals and Review Unit, took a careful and detailed approach to examining all the new evidence to ensure that the previous acquittal would be quashed by the Court of Appeal. Our Appeals and Review Unit took the compelling new evidence to the Court of Appeal and argued successfully that the case should be retried. In the light of that, further additional charges were brought by the Crown Prosecutor's Service, reflecting the lies that Robert Rhodes had told at his previous trial. None of us can even begin to imagine what Rhodes put the child witness through over the last few years. As a result of their evidence, everyone now knows the truth. Dawn did not attack Robert Rhodes that night. She was the victim of her violent husband. And we hope that the verdict and the outcome of this case brings some comfort to Dawn's family and friends, and of course to the child witness. Thank you very much.
Thank you. Good afternoon. I am Detective Chief Inspector Kimberly Dee from the Surrey and Sussex Police Major Crime Team, and the Senior Investigating Officer for the case involving the murder of Dawn Rhodes. Today, Robert Rhodes was sentenced to 29 years and 6 months for the murder of his wife following an 8-week retrial at the Crown Court sitting at Inner London. Rhodes was originally acquitted of the murder of his wife Dawn in 2017, but was subsequently found guilty on the 12th of December 2025 after new evidence came to light which resulted in the retrial. Rhodes was also found guilty of child cruelty, perverting the course of justice, and 2 counts of perjury. I would like to extend my heartfelt condolences to the family and friends of Dawn Rhodes. The loss that they have suffered is immeasurable and cannot be underestimated. They have had to deal with the fact that Robert Rhodes got away with murder for 9 years, all the while knowing the misery and suffering that he had inflicted on Dawn, not just on the night that he killed her, but also leading up to her death. I must also pay tribute to the child and their tremendous bravery in coming forward years after Dawn's death to tell the truth about what happened. It should be acknowledged that the child was under the age of criminal responsibility at the time of Dawn's death, and that they were not responsible for the acts that Rhodes manipulated them into doing. The realisation that they were complicit in Dawn's death and coming forward to set the record straight 9 years later is nothing short of extraordinary. The fact that Rhodes not only murdered his wife in cold blood, but then manipulated and groomed a child to play a part in his evil scheme, and cover up what he'd done is simply despicable. Not only did he take a life, he irreparably damaged another, as well as the lives of anyone else and everyone else who loved Dawn. During the first trial, Dawn was portrayed as the villain, but she had actually been a victim of domestic abuse and coercive control at the hands of her husband for years. Dawn's tragic death draws attention to the need to dispel and challenge myths and stereotypes around who may or may not be victims of domestic abuse, and who indeed may be capable of causing such harm. Otherwise, many victims will feel unable to reach out and will continue to suffer in silence while those causing harm in relationships are able to exist unchecked. We would urge anyone who believes they or a friend or family member may be experiencing abuse to report it. If you have any concerns at all for yourself or a loved one, please seek help. In Surrey and across the country, there are specialist domestic abuse services working to ensure that survivors and their families and friends can access independent advice and support in confidence. I would like to extend my thanks to the investigation team for their tireless work in leaving no stone unturned to ensure that Rhodes was brought to justice. A very special mention must also be made to the family liaison officers who went above and beyond what would be expected of them to assist the families throughout this investigation. I would like to thank our partner agencies, particularly the Crown Prosecution Service, for their support and advice, the witnesses who assisted in giving evidence which helped to bring out the truth of the events from 2016, helping to piece together Robert Rhodes' web of deceit, and the jury for their careful consideration of the evidence which has been presented throughout this trial. Thank you very much.
Two, three, four, five.
Sorry, mate. Thanks very much.
That's okay.
Just
Dump it on